Welcome to our podcast, Psychiatric Services, From Pages to Practice. In this podcast, we highlight new research or columns published this month in the journal Psychiatric Services. I'm Lisa Dixon, editor of Psychiatric Services, and I'm here with podcast editor and my co-host, Josh Berezin. Hi, Josh.
Hi, Lisa.
Today, we are going to do an interview. We are going to interview Dr. Paul Appelbaum, who is the editor of the Law and Psychiatry column. And we are going to be focusing on responsibility for suicide or violence on campus. And I just want to say that this particular topic is personally very meaningful to me because my brother, who developed schizophrenia, became quite ill during college and actually then medical school. And it still is something that my mother remains very upset and angry about, that at no time during his days in school, when he was obviously in retrospect quite psychotic, was there any notice taken or help given to him. And so while the focus of today's column isn't exactly on that scenario, I feel like this is something that means a lot to me personally.
And it's a great conversation. We just got off the line with Dr. Appelbaum, so I think it'll be a really interesting piece for our listeners, and was interesting for you given your history with this issue. So we are very lucky to have today Dr. Paul Appelbaum, who's the Elizabeth K. Dollard Professor of Psychiatry, Medicine, and Law at Columbia University. So welcome, Dr. Appelbaum.
Thank you. Nice to be here.
Thank you so much for joining us. So you're also the editor of the Psychiatry and the Law column at Psychiatric Services, and we're going to be talking today about the most recent column, which is responsibility for suicide or violence on campus. And when we do interviews, we like to start with asking people how they got interested in this topic. I know you have a wide range of research interests, but how did you focus in on this one?
Yeah, well, this one actually came to me by virtue of the column. I've been writing and editing the column since 1981.
Wow. So
I'm always on the lookout for interesting cases or issues. And about 13, 14 years ago, I learned of a case of a student at George Washington University in the District of Columbia who had gone to the hospital complaining of suicidal ideation, and as a result had been expelled from the university and barred from setting foot on campus. The university's response seemed to be driven largely by their concerns about liability, and frankly, not very much at all about their obligations towards taking care of their students. So that was what first got me into this area, and it's something I've kept an eye on ever since.
And so now there's been a couple of recent cases that have brought this more into the spotlight. I thought maybe it would be, as you do in your column, a good way to start by just describing the two cases, because they both bring up all these issues up to the fore.
Yeah, so they're cases from major universities on different sides of the country, but with a common thread to them. The first of the cases arose at MIT in Cambridge back in 2009, when a student who had been having some problems and seeing mental health professionals outside of the university and unbeknownst to the university, who had some problems with test anxiety and gotten some special accommodations for him, but had resisted all efforts to refer him to the student counseling service. When this student had written an intemperate letter to a researcher with whom he was set up to do a summer project, and in response to that email, his advisor reached out to him by phone, and as he later recounted the interaction, said he had read him the riot act. A few minutes later, the student went to the roof of the laboratory building in which he was working and jumped to his death. So that was the first of the cases. The second case came from California, from UCLA, and involved an undergraduate who had a long pattern since his transfer to UCLA in 2008 of making complaints about other students or professors who he said were making derogatory comments about him, sometimes talking in ways that he could hear through the walls of his dormitory room that he found disturbing and threatening. And there was at least one episode where he confronted another student and pushed him, and that led to an emergency psychiatric evaluation. But the student never consistently went to sessions at the student counseling service, never consistently took the medications that had been prescribed for him. And then in the fall of 2009, ramped up his complaints about other students who were making racist comments about him or criticizing him, he felt, in some way. And suddenly, unprovoked, for no reason anyone could discern, took out a kitchen knife and stabbed the student next to him in chemistry lab, a young woman who was stabbed multiple times in the chest and neck and who fortunately survived. So both of these cases led to the filing of lawsuits. The student who committed suicide's family filed suit against MIT, alleging that they had been negligent in failing to prevent the suicide. And the student who had been stabbed at UCLA sued that university with a similar allegation, namely that they had failed in their duty to protect her from what she characterized as a foreseeable assault.
Paul, I'd love to ask a few questions about these stories before we move on to the analysis, because a couple of things jump out. One is, and you said this clearly, unbeknownst, with the first case, unbeknownst to the university, he had been pursuing some kind of counseling or treatment. Did I get that right?
Yes, that's right.
But he had gotten some accommodations, correct?
Right. Correct.
So on some level there was knownst, right? If he pursued some accommodations, it had to have been on the basis of some kind of information or data.
Right. So he said he was having trouble with test anxiety, and the accommodations included longer periods of time to complete examinations and similar sorts of accommodations. But there was no hint that the university was aware of that he was suffering from depression, which he was, or that he had been having suicidal ideation, or that some years prior to his admission to the university, he had apparently made 2 suicide attempts, although as far as we're aware, we don't know how serious those attempts were.
So what the university knew was something, but not what was related necessarily or directly to the suicide.
Correct.
Is that right? Okay.
Yes.
And when you brought up these, when you were describing the cases, you used this term that from the rest of the article seems like, or the rest of the column, it seems like is really important, which is duty to protect. So can you kind of lay the groundwork about what sorts of questions the court is thinking about and what the legal framework is when they're trying to decide if a campus or university has some responsibility for these episodes?
Yeah, in the common law, there is no ordinary duty of one person to protect another person from harm. And so in the extreme case that first-year law students are often told about if you're walking past a wading pool and you see a toddler slip and fall and start to drown. You have no legal obligation to save that toddler, even if you could do so easily and with little bother to yourself. It's shocking to many people.
Yeah. I was going to say, I did not know that.
Yeah.
I thought you had to dive in.
I would not say that's the morally appropriate course to take, but the law has been reluctant to impose affirmative duties to protect or rescue in cases of that sort. But there are exceptions. So if you were that toddler's parent, the law would deem you to have a special relationship, that's the term that's used, with the toddler, that imposes on you an obligation to protect that toddler, and you indeed would have the obligation to rescue him. So what becomes the legal touchstone in these cases is whether a special relationship exists. But special relationships are not created in nature. They are instruments of policy. And so it's the courts or occasionally legislatures that decide whether it's good policy to recognize such a relationship or not. And that's the key analysis that goes on in both of these cases.
So let me just make sure I got this. The court is deciding if there's a special relationship between universities and their students, which means if they do have a special relationship, that means that they have a duty to protect their students.
Right. And we can talk more about what the dimensions of that duty might be. But in each of these cases, the university asked for the complaint to be dismissed without trial on the basis that they had no special relationship and therefore no duty, and the litigation that followed focused on that claim.
So what did the courts find in both of the cases?
Well, in the Massachusetts case, in the MIT case, the Supreme Judicial Court in Massachusetts recognized that there was a duty that universities had to take reasonable care to protect students from self-harm in this case, but they limited the duty to a very specific set of facts. And let me read you the quote where the court lays out what the scope of the duty is. They said that this duty to take reasonable care to protect a student existed where a university has actual knowledge of a student's suicide attempt, that is, prior attempt, that occurred while enrolled at the university or recently before matriculation, or of a student's stated plans or intentions to commit suicide. So to put that in sort of ordinary language, if you're a college or university and your employees become aware that a student either recently attempted suicide or currently has plans or an intention to commit suicide, then your duty kicks in. Short of that, however, no duty would apply.
So like Lisa was asking before, this person asked for a reasonable accommodation, but there was no indication that it had anything to do with depression or suicidality. So the university doesn't have the duty to protect in that situation. Is that right?
And that, in fact, is what the court concluded. Indeed, the court underscored that it wasn't talking about suicidal thoughts, suicidal ideation, which are quite common in college communities. Indeed, some data suggest that up to 10% of college students in any given year experience suicidal ideation, which is sort of a staggering number, but has been confirmed in more than one study. But it's got to go beyond that before, at least in Massachusetts, the courts would find that there's a duty to try to prevent harm from occurring.
So going beyond means having a plan?
Having a plan or actually having attempted suicide in the recent past.
So what does it mean that the university knows? What is that? The university knows. How does the university know? How does that play out in real ways?
So I think what that means in real life is if an employee of the university, which could include a professor or could include somebody working in the student counseling service or the dean of students office, becomes aware that one of the conditions that triggers the duty exists, then the university will be held to have had actual knowledge that a duty applied.
So someone employed by the university.
Correct.
So it really, some of these issues I think that we'll end up talking about later on, for example, counseling centers. What are they employees of the university? What are they? To what extent are they arms or instruments of the university? It gets kind of interesting.
Yeah, it is. It is kind of interesting. So in some universities, some of the larger universities, MIT is an example, a counseling center exists, and the counselors there, psychiatrists, psychologists, sometimes other mental health professionals, are employees of the university. So their knowledge of a student's suicidality would be imputed to the university as a whole. Other universities, however, or smaller colleges, contract out for student health services. And arguably, although we'd have to see how the courts come out on this in a real case, but arguably, since those people are under contract, not employees, knowledge that they become aware of would not necessarily be considered to constitute knowledge of the university.
Interesting. And so how did the courts find across the country in California for the other case?
Yeah, so in the California case, recall that the student sued UCLA for failure to protect her from the stabbing assault. UCLA asked to have the case dismissed. The trial court refused, but an appellate court agreed that there was no special relationship and therefore no duty, and the case was appealed to the California Supreme Court. In contrast to the position of the California mid-level appellate court, the Supreme Court held that there was a duty, although they too limited its scope. They noted, and let me read you some of the language here, that students are dependent on their college communities to provide structure, guidance, and a safe learning environment, and in turn have superior control over the environment and the ability to protect students. And therefore, the court held that so long as students are engaged in educational activities that are part of the curriculum, for example, being in chemistry lab, or closely related to educational services, and it's a little vague what exactly that encompasses, when it's foreseeable that harm may occur, the university has an obligation to protect students from that harm.
So the take-home from both of these cases are that there are situations where universities have a duty to protect their students and could potentially be liable when there's an episode of violence or suicide.
Correct.
I have some questions about the second case too, as well, so thinking out loud with you, Paul. What does foreseeable mean here? Foreseeable risk? How would you define foreseeable, particularly in light of the fact that we have so little ability to predict violence or suicide?
So foreseeability is a legal term of art, which has become the touchstone in many jurisdictions for the imposition of tort liability. You are responsible for your actions if they could foreseeably cause harm to another person. And as your question implies, and I think correctly, what's foreseeable and what isn't is often very difficult to say. And that's precisely the task that's assigned to the jury in cases like this. They are asked to determine whether it was reasonably foreseeable, for example, that the student at UCLA would violently assault another student, or that the student at MIT would have taken his own life.
Mm-hmm. Another question that pops into my mind as you're talking is the issue of the risk or dangerousness, danger to the self in the second case. So when you have somebody, or when it's someone's behavior in a school setting is obviously paranoid or disturbed, there may be danger to others, but also danger to oneself due to illness or the lack of treatment. And I was, as someone who has a brother who was in college and in medical school for many years with a clear psychotic diagnosis, now in retrospect, it makes me wonder whether, sort of along the lines of reasoning of the second case, whether there's not a really important obligation to help an individual seek treatment.
So one of the things the courts are trying to do in both of these cases is to limit the scope of the duty being imposed on the universities as a matter of law. And I think it's important for us to underscore that what your legal obligations are, whether as a person or as a corporate entity like a university, are not necessarily the same as your moral obligations. As a university, if you are aware that a student is having a lot of trouble, behaving oddly, may be in the early stages of a psychotic illness, I don't have a lot of trouble saying that you've got a moral obligation to reach out to that student and try to provide support and referral to treatment. The question, though, that the courts are struggling with are, at what point does that moral obligation become legally enforceable? And of course, if it's legally enforceable and you fail to do it, then you can be held liable for the harms that result, which could mean a substantial financial hit to the universities.
So do you think that the legal framework that the courts have come up with in these cases is leading to what we would consider a good, either a moral or clinical outcome for student mental health?
So I have some concerns about the consequences of extending the special relationship analysis to colleges and universities. And the concerns are undergirded by what has been the not always happy history of how colleges and universities have behaved with students with mental illness. Which is to say, when they have worried about liability, they have often acted in ways that were much more self-protective than directed at the student's best interest. So the case that we started talking about that got me interested in this area 15 years ago in the first place is an example of that. Many colleges in that era, and some even today, had policies that said if you reported suicidal ideation, you had to take a leave. It was not optional. It was mandatory. You had to leave campus. And although, you could say, well, that's for the student's benefit, in fact, it's not at all clear that in all cases, cutting a student off from their friends and their classes and their support system at school is likely to be beneficial. What it's beneficial for is the university's record of avoiding suicide on campus. So the more we impose liability risks, frankly, the more incentive colleges and universities have to put their own interests first and to perhaps subordinate the interests of their students. And I think we need to understand that in the context of the difficulties we have in predicting rare acts, and suicide and homicide or serious assaults are, in the bigger scheme of things, rare outcomes. And efforts to predict rare outcomes always result in overprediction.
So go ahead.
Yeah, well, that means that many more students will be identified and perhaps responded to in ways that could be counterproductive than actually present a risk to themselves or other people.
So you're worried that this will cause more harm than good in some ways for individuals experiencing mental disorders or difficulties.
Yeah, in the extreme, there was, in the California case, a friend of the court brief that was filed by a group of organizations led by the JED Foundation, which are concerned with mental health on campus, that suggested that the consequences of imposing broad liability might be that some colleges or universities would dissolve their counseling services so that there was no likelihood or a reduced likelihood that they would learn about the problematic ideation, whether suicidal or homicidal, of their students. It's sort of a see no evil, have no duty approach to this issue.
Do you think that the courts had found differently that there wasn't a duty to protect? It would have encouraged universities to have a more kind of appropriate clinical and epidemiological response.
Well, and moral response to provide more support and services.
I'm not sure it would have encouraged them to do the right thing any more than they are encouraged today, but it would not have disincentivized them from doing so, which is the concern that I have as the degree of liability risk ramps up.
So, Paul, we're going to wrap up, but I wanted to ask you, what are the key take-home points here for the psychiatric services reader, again, who spans researchers, clinicians, people who run agencies, other stakeholders, perhaps family members, people who are service recipients? What should we take away from this really interesting, complex set of issues?
So one of the key take-home points, I think, is just how complicated this situation is. To the extent that we impose liability on colleges and universities to protect their students, either from themselves in the case of suicide or from others in the case of foreseeable violent assault, we may be incentivizing them to take appropriate measures, whether providing treatment or increased security or the like. But we may also be disincentivizing them from providing appropriate mental health services or from retaining students and making efforts to keep them on campus instead of expelling them or putting them on leave and sending them home. And colleges and universities faced with these new obligations and the mental health folks who work for them, I think, need to be conscious of the pressure towards self-protection that the universities have and attempt to resist that pressure and argue for the provision of appropriate services and the avoidance of counterproductive actions such as putting students reflexively on leave when it's not in their interest.
Well, thank you so much for joining us and making this incredibly complex issue a lot simpler for at least me and Lisa and probably all of our listeners. We really appreciate it.
And thank you again
pleasure.
for the how many years of service since 1981? We have another complex math problem today, 2019.
Yeah, so it's 38 years
38
that this column has
years
been going on.
of service.
Well, we look forward to more.
Yeah.
Thanks again.
Okay, thank you. Bye.
Bye-bye.
Bye. Well, that's it for today. I'm really grateful to Dr. Appelbaum for that discussion, which really did help me to understand some of the important considerations around the experience of my family and my brother while he was having mental health issues in college and med school. So we invite you to visit our website, ps.psychiatryonline.org, to read the column we discussed in this episode, as well as other great research. Also, we remind you to check out the Editor's Choice topic collection, available now. Sign up at appi.org/ETOCS, appi.org/ETOCS. We also welcome your feedback. Please email us at psjournal@psych.org. I'm Lisa Dixon.
I'm Josh Berezin.
Thank you for listening. We'll talk to you next time.
Bye-bye.